Good morning. Is the panel ready to proceed? All right, hearing no objection, the case before the court is Richard Lee Desautel, the appellant, versus Her Majesty the Queen, the respondent. For the appellant, we have Mr. Ini Adedopo and Mr. Humza Khan. And for the respondent, we have Ms. Rebecca Tiley and Ms. Avery McKinley. I would now call on the appellant, first speaker for your 12-minute argument, please.
Morning, Justices. My name is Inilu Adedapo, and my colleague's name is Humza Khan, and we represent Her Majesty the Queen in right of British Columbia, and we will be presenting 4 submissions as the appellant today. I will be presenting the first 2 submissions in regards to Section 35 and whether claimants outside of Canada can rightfully claim protection under Section 35 of the Constitution Act of 1982. My colleague Humza Khan will be presenting the last 2 submissions in regards to the claim of continuity in regards to the Van der Peet test. Before we begin, would you like a brief summary of the facts?
And counsel, please excuse me for getting the parties wrong earlier. I'm certainly aware, at least I am now, that Her Majesty is the appellant.
No worries, Justice. Thank you. As we begin, it's important to note that while we should be generous in our interpretation of constitutional provisions, conferring rights upon people, we must also be careful to not be too flexible in our interpretation, and we must seek to interpret them in the intended purpose in which the original framers intended to draft them. As such, we note that Section 35 provides constitutional protection only to the rights of the Aboriginal peoples of Canada. The main issue here today is in regards to the ambiguity of the text, Aboriginal peoples of Canada, and whether the phrase Aboriginal peoples of Canada only applies to those groups of which the modern successors continue to live in the geographic location of Canada.
Counsel, I'm going to interrupt you. In terms of your statement about the drafters of Section 35 and the Constitution Act, you would acknowledge that there is no indications that the idea of Aboriginal peoples outside of Canada was ever considered, correct?
In what regards, Justice, if you could clarify just the last bit?
We have Hansard transcripts, we have comments made from the drafters at the time, and there's no indications within any of those materials that the idea of Aboriginal peoples outside of Canada was considered while drafting that section.
Yes, that is correct, Justice.
Okay, and can you tell me about how you would contemplate the French version du Canada in terms of its more lenient meaning as from Canada as opposed to of Canada?
In regards to how we would contemplate the French version, we would submit the same approach that we would take with the English version, which is I would present a textual analysis and a philosophic analysis. And we submit that the textual analysis, regardless of whether the English or the French version, would still come to relatively the same conclusion, that the phrase of Canada, when used in other parts of the same legislative text, does refer and act as a geographic qualifier, Justice.
Carry on.
And then we respectfully disagree with the Court of Appeals methodology in presupposing that the Van der Peet test is sufficient group, a part of Aboriginal peoples of Canada. To do this, we must make a distinction between 2 separate questions that are similar but fundamentally different. The first question is whether a group of people counts as the Aboriginal peoples of Canada or whether they have Aboriginal rights. The Van der Peet test only answers the second question, not the first question. As such, this is a threshold question, which means that we must answer the question first before we then go on to apply the Van der Peet test to the claimants. First and foremost, then once we move on, we see apply a textual analysis. The phrase of Canada appears elsewhere in the legislative act. We understand that subsection 1 is not an isolated piece of text, such that if we try to understand it, we should try to do it within the broader context of the other sections of the same legislative act.
Counsel, I'm going to interrupt you again. When you say that it is a threshold question, what exactly is that threshold and what does it consist of?
By saying that it is a threshold question, what we submit is that we must first answer the question whether a group qualifies to be considered Aboriginal peoples of Canada before we move on to the Van der Peet test, which only talks about whether this group has Aboriginal rights.
Okay, and so so of Canada, you think that that's the only, I'm asking you to break down what the threshold is and how you would consider it.
In regards to the phrase Aboriginal Peoples of Canada, Justice?
Yes, what threshold, what would be the tests that they would have to meet?
The test they would have to meet once we complete a textual analysis of what the intention of the original drafters is, the threshold they would have to meet then is what we believe is the geographic qualifier. That's what we're trying to seek, whether the original drafters intended the phrase of Canada to be a geographic qualifier. As such, we submit that they don't meet that threshold of continue to live in Canada. As such, we submit then that Section 35, they cannot appeal to constitutional protection of their rights under Section 35.
Okay, so the threshold test for you is just a geographic issue. It doesn't take into account citizenry or anything like that.
In a sense that just like they also are not within the scope of the country of Canada, they also do not have they are not Canadian residents. The respondent is not a Canadian resident or citizen in the same sense. As such, we would say that yes, they would have to be Canadians, Canadian Aboriginals to be considered within this and also live within Canada, have their residency in Canada.
Okay, so the threshold question that you're saying it is both residency, i.e. citizenry, and geographic location.
Yes, Justice.
Okay, is there anything else that you would consider under that threshold test?
Perhaps continuity, but that would relate more to the Vanderpeet test, Justice.
Okay, move on.
Counsel, you speak of this philosophical approach and the intent of the drafters, but isn't the Constitution itself a living tree? And wouldn't we think that to impose these continued colonial structures of borders, which is a colonial structure, national identity as Canadian versus US, and not another colonial structure, is that not continuing the case law of re-Eskimo of the colonial order determining who is an Indigenous person, who is an Aboriginal person?
In response to that, Justice, we would submit that if we look at Manitoba Métis Federation against the Attorney General, which we personally do agree with the living tree doctrine of the Constitution, that it is a living, breathing document. As such, we're not simply applying a formalistic argument. What we are submitting is that we must, while being generous in our interpretation, stay with, have some level of consistency with what the original framers would have intended.
Counsel, if we talk about intention and textual analysis of that phrase, Aboriginal Peoples of Canada, doesn't the word Aboriginal mean original, those who were here in the first place?
Yes,
so when we say Aboriginal Peoples of Canada, we're talking about those who were originally in what is now Canada. Does that not include Mr. Desautel?
In regards to that, Justice, yes, the phrase, the word Aboriginal does mean original and such. If we read in the phrase, Aboriginal Peoples of Canada does refer to those people who were here prior to European contact. We have absolutely no contention with that. However, the issue that we are raising is that those people upon which the rights of Section 35 should continue to be conferred who are the modern day successors of those groups that continue to live within the boundaries of Canada. As such, we believe that if we were to broaden this definition to successors that are outside the boundaries of Canada, this would create some devastating public policy consequences.
Okay, and is it you, counsel, who's going to be talking about these public policy consequences, or is it going to be your co-counsel?
I will be talking about them, Justice.
Okay, can you move forward and talk about those, please?
Following from that, we will now focus on the public policy issues. And we note that Aboriginal rights also include rights to the land itself, and to have Aboriginal groups outside of Canada have the potential ability to hold constitutionally protected rights to Canadian sovereign land would cause some issues. For example, we know, and I apologize if I butchered the name, Courtroom Nation against British Columbia, we know that it states there that Aboriginal title does confer a right to the land. So it's not only site specific, it's a right to the land itself. And this is not merely a hypothetical issue. We note that the CCT, the Confederation group that the Lakes tribe, of which the respondent is a member of, have already
filed. But counsel, you would acknowledge, would you not, that this is not a land title case. This is a right to hunt on land, but it is not a land title case in and of itself.
Yes, Justice, that's correct.
Okay, and so you'd also agree, or would you, that test for land title, where would that come from?
My apologies, Justice. You cut off at the end. Did you ask where would that come from?
What jurisprudence does the test for land title come from?
And could you just clarify that a bit? My apologies.
If an Aboriginal group was seeking rights in terms of land title, what case did that test come from?
I pointed to the Courtroom Nation v. British Columbia, paragraph 88, which stated that if we do confer Aboriginal rights to people, to a group, then they do have rights to claim land to title of the land. My apologies.
Counsel,
I think,
how is Aboriginal title held?
In regards to how they conferred or held by the group?
Well, how do you, just in your own perspective, just communicate to me, how do Aboriginal rights, how are they understood in an Aboriginal community?
I would, in my own perspective, and I would understand that Aboriginal rights are held.
Or title rights, sorry, that's what I meant, title rights.
Title rights are essentially held, I would believe, communally, but I might be wrong on that.
So they're communal, counsel. So this hunting and gathering that Mr. Desautel is doing, is he exercising his Aboriginal rights for his community in a communal aspect?
Yes, we would say he is, Justice.
So why shouldn't he have that right?
Once again, the argument then goes back to, as we agree, yes, he is performing communal rights that he does have, but the problem is that we are submitting that the modern day, the Lakes tribe cannot be counted as, the Lakes tribe cannot have constitutional protection under Section 35 as they are outside the boundary of Canada geographically, and nor.
Counsel, is this purely a statutory interpretation case? Are
Not
we really just looking to decide how Canada is being used in that context?
Not necessarily, Justice, no. My apologies, sorry, did my answer go through or?
I got it, yeah, thank you.
Yeah, so if I may proceed then, or if barring any further questions?
I think what I wanted to make clear is that this is a case for Aboriginal rights, which would be decided under Vanderpeet. I don't want to hear any further submissions on land title because that is a completely different test that originated in Delgamuukw. So no more, I don't want to hear any more submissions on the title issue. Move forward.
Unfortunately, Justice, I would love to submit on that, but I see that my time is out. So I'll just take the last few seconds to introduce my co-counsel who will talk about the prongs of the Vanderpeet test and the claims to continuity. Thank you, Justice.
Thank you.
Good afternoon, Your Honor. Good afternoon, Justice. My name is Hamza Khan, and along with my co-counsel, Aniolo Adedepo, we will be representing the appellant in this case. I have two main submissions here today. The first is to elaborate on some of the public policy implications of this lower court decision. And the second, if I have time for it, will deal with the continuity issue of the Vanderpeet test.
Counsel, not if I have time for it. I think continuity is a really important issue for this panel. Not to speak for my colleagues, but I know it is for me.
And I'll also get to continuity. I'd just like to address some of the public policy issues first, because that's some of the things that my co-counsel had brought up. I believe it was discussed here that the Constitution is a living, breathing document, and to interpret in certain ways may uphold some colonial structures or some colonial systems of oppression against Aboriginal groups. And the appellant definitely acknowledges this and wholeheartedly agrees with this. And this is why we have to consider the consequences for Aboriginal groups within Canada of this lower court decision. Namely, how the rights of the Lakes tribe within British Columbia would interfere with the rights of those other Aboriginal groups, which exclusively reside within that area and exclusively reside within British Columbia without residing in another state, such as the Lakes tribe. Central to this is the fact that the Lakes tribe—
Counsel, I'm going to interrupt you. Is it not a bit patronistic to submit to the court that you know or understand what the position of other Indigenous groups in the area would be? Would it not be for a matter of consultation and negotiation to determine how those other Indigenous groups would be affected?
I think that's definitely a good point there, Justice. And I'm not suggesting that I have full knowledge of any Indigenous groups within the area. However, without the absence of an intervener or any consultation at this trial, I'm simply trying to elaborate on some of the possibilities that might come down the line, as this doesn't specify just the Aboriginal groups involved in this case, potential future possibilities of conflict with Aboriginal rights. And so I'm not just trying to represent those groups that might apply to this case, but those groups which I'm not aware of, which might apply to future cases decided on the merits of the lower court decision. And so getting to that, we know that the Snakes tribe, some individuals within that group had remained within Canada. Now, unfortunately, the government had declared them extinguished, and we submit that to take away their rights or to give away their rights to the Lakes tribe simply on the basis of their extinguishment, which we submit was a mistaken decision to say that the Snakes tribe no longer exists in Canada, would be upholding those same colonial values. The Snakes people still exist within Canada, regardless of any extinguishment declaration by the government that was made without the consultation of the Snakes people and unilaterally. And
Counsel,
yes.
Counsel, I just want to ask you about the Vanderpeet test.
Right.
This is just a quick yes or no. Did the trial judge get that wrong?
Yes.
Okay.
We will. Sure.
Okay, you can, if you want to hold it to later, but I'm interested to know why we still shouldn't defer to her, even if you think she got it wrong. Why doesn't this court owe her deference?
Sure. So I'll wrap up quickly with public policy, and I'll move on then to continuity, because I see that's a legal issue you would like me to move on to. Just quickly to wrap up, we know that some of the Snakes people who originally remained in Canada were wrapped into the Tunexa tribe, and they comprise the group of the Arrow Lakes region. And so to enable other groups to in some instances infringe upon those rights or to claim rights would interfere. Sorry, did you have a question, Justice? Would interfere or may cause some conflict with those groups which already have title and already have presence within the area of the Arrow Lakes and within the area of British Columbia. To move on then to the question of continuity, we acknowledge and we submit that we do owe the trial judge deference in this case, as continuity is a fact-specific issue. However, we submit that the facts as the trial judge found them cannot amount to continuity in this case as a matter of law. And the basis for that is that when the lower court made their decision, they stated a period of dormancy between 1930 and 1976. However, we would submit that this period of dormancy is mistaken and it was actually longer. Justice, if you're asking a question.
Sorry, Counsel, I just want to, would it not be an important aspect of reconciliation that the factors that may have played into that dormancy period should be considered in the ultimate continuity test?
Yeah, that's perfectly legitimate, Justice, and I will get to those factors. There is some aspect of coercion in the fact that they had not been able to exert their rights over this land, that there were some coercive forces within the early 20th century that prevented them from doing so. However,
so how would you justify then, in the whole era of reconciliation, how would you justify denying an Aboriginal group rights because their rights have been dormant because of colonial factors? How would you justify that?
Justice, we would justify that by some of the public policy implication that we were getting to before, that there is already an Aboriginal group within that area that contains some of the original members or the direct descendants of the Snakes people who already exhibit their rights within the area, their title to hunt, as well as land title claims within the area. And so while we recognize that the Lakes tribe may have some claim or may have some interest in having title, we also recognize that in the interest of reconciliation, the priority of the Canadian government would be those Canadian Aboriginal groups residing within Canada. And so we don't believe, we submit that without further consultation with those individuals and without further review of how this would impact their hunting rights and their land title rights, we submit that it would be wrong for us to unilaterally give away some of their rights to outside groups or groups that don't currently reside within Canada.
So what is your intent in framing this test then? Because we've heard from your co-counsel that there is a threshold that needs to be met in terms of geographic location and residency. And now you're indicating that there should be some consultation with other groups. I want to know exactly, once the threshold test is met or not, what would you outline as being the next step in order to be able to utilize rights in Canada?
Well, Justice, the threshold test is specifically referring, I believe my co-counsel was referring to Section 35, but obviously past that, we have to look at the Vanderpeet test to see if they can have legitimate exercise of that Aboriginal right. So the process I would outline, or we submit that we should outline, is to evaluate Section 35 to see if groups outside of Canada can apply for Aboriginal rights and Aboriginal title. And if you find arguments by my learned co-counsel convincing that it would apply, we then also need to look at the Vanderpeet test and to see if both of these conditions are satisfied, both Section 35 applying and the Vanderpeet test being satisfied in regards to continuity. So in terms of continuity, I'd just like to wrap back around because I believe it's, and we've seen that it's an issue at hand.
Counsel, my question is about continuity as well. I want to know from your perspective, it seems like your analysis is speaking largely of like common law ideas of evidence. And I want to know if the Indigenous perspective is being considered here in terms of evidence of continuity in this particular place.
Yeah, Justice. So in terms of evidence, here is a place where I would defer to the trial judge's conclusion of the facts of the matter when they evaluated evidence both from Aboriginal experts as well as Aboriginal individuals and witnesses themselves. When the trial judge determined that there had been no hunting post the period of 1930. And so while we recognize that the standards of evidence must be modified in terms of Aboriginal rights cases, because often there is no set detailed record, we submit that we should defer here to the finding of facts as they were in the trial case, which is that there was no hunting post 1930, at least no coordinated or cultural exertion of hunting rights within British Columbia.
Which you admit was frustrated due to colonial laws.
And we do admit that, Justice. However, we submit that to now give back those rights or to give away those rights that are exerted.
I don't want that phrasing used. You don't give back Indigenous people rights. Those rights always were there in and of themselves. So that's inappropriate. Move on.
Okay. I'll move on then, Justice, just to wrap up quickly. I'll move on, Justice, just to wrap up what me and my co-counsel has stated. My co-counsel came forward here today and gave submissions regarding Section 35. And Section 35 was that Aboriginal groups outside of Canada cannot apply under Section 35 due to the original phrasing as well as textual analysis of Section 35, showing that Aboriginal groups of Canada must refer to those individuals who reside within Canada. Further, I presented public policy considerations that to uphold the lower court's decision in this case, may infringe or may cause conflicts with those individuals currently residing within Canada, those Aboriginal groups who had negotiated with the original Constitution Act of 1982 and who have a vested interest here in this case.
Counsel, I'm just going to interrupt you. And so your position is that could not be resolved through duty to consult and negotiation with tribes within Canada and outside Canada. Your position, that would be too hard to undergo and you wouldn't support it.
Not that it would be too hard. We aren't submitting that it would be onerous on the Crown. We submit that it is the Crown's responsibility as the perpetrators of some of this oppressive power in the past to consult and to reconcile. However, we submit that there could be irreconcilable differences caused by conflict between those that were the original inhabitants that have moved down to the United States and those who currently reside within Canada. And so not that it would be irreconcilable, but that any conclusion might have a negative or deleterious impact on those individuals who currently reside within the area that's being discussed here, namely the Haudenosaunee and the descendants of the Sinixt individuals who've remained within Canada following the migration of most of the group to the United States. And so because of this deleterious impact and the issue of continuity, we ask that you overturn the lower court's decision and reinstate the charge against Mr. Desautel. Thank you.
Okay, I will call on the respondents. Ms. Tiley and Ms. McKinley.
Good afternoon, Honorable Justices of the Court. My name is Rebecca Tiley, here with my colleague Avery McKinley, and we are here on behalf of the respondent, Mr. Richard Lee Desautel. At issue before the court here today is that an interpretation of Section 35 that excludes the Lakes tribes would undermine the fundamental nature of Section 35 and defeat the constitutional promise that Section 35 represents to protect Aboriginal rights. Therefore, it is the respondent's position that the Supreme Court of Canada was correct in determining that Sections 11(1) and 47A of the Wildlife are of no force or effect with respect to the application of Section 35 of the 1982 Constitution Act to Mr. Desautel. We respectfully request the Supreme Court of Lions Cup to uphold the lower court's decision, exempt Mr. Desautel from the Wildlife Act provisions under which he was charged, and dismiss the appeal. To this end, the respondent has two submissions to make today. I will submit the first, and my colleague will submit the second. The first submission is that under the scope of Section 35 of the Constitution Act, the phrase Aboriginal peoples of Canada does include Aboriginal people outside of Canada. The second submission is that Mr. Desautel does have the right to hunt, as the requirement for continuity under the Vanderpeet test for Aboriginal rights has been met. To begin with the first submission, before turning to why residency and citizenship requirement is fundamentally contrary to the purposes of Section 35, I would like to first address the linguistic context that our friends raised. Our friends submitted that the words of Canada under Section 35 should be read in line with the rest of the Constitution. However, we submit that it should be read as a whole phrase in its entirety, Aboriginal people of Canada, and that because Section 35 has a specificity to Aboriginal peoples, when reading Section 35, the court must also acknowledge the one fact that separates Aboriginal peoples of Canada from all other minorities in Canada. And that is the fact that Aboriginal peoples were here occupying the land in distinctive societies prior to the arrival of Europeans. Therefore, we submit that in taking into account the linguistic context of this provision, the court must also recognize that as a result of colonization and the assertion of Crown sovereignty, there may be relevant collectives that are now located outside of Canada. This is a novel issue before the court, and it may be true that in 1980, when the minutes were drafted, or 1982, when the Constitution was drafted, that the drafters did not contemplate that there might be Aboriginal peoples of Canada, Aboriginal peoples outside of Canada that should be included within the provision. The Constitution must be interpreted in a manner which renders it capable of growth and development over time to meet new social, political, and historical realities that were often unimagined by its framers, as stated in the 1984 Supreme Court of Canada case of Hunter and Seldom. And while Hunter and Seldom, sorry, was there a question there? While Hunter and Seldom was about the interpretation of Section 8, the application of this principle was recognized in the context of Aboriginal rights and under Section 35 in the 1996 Supreme Court of Canada case of the Crown and Vanderpeet.
Counsel, I'm going to stop you. And I'm going to just ask you a question in respect to reconciliation, that theme. You can understand that there are certain types of legislation, like for instance, the Indian Act, that governs, restricts, and tells you who can be considered Indian and who could assert certain rights. And there's people who would consider themselves as Indigenous people that cannot assert certain rights because of this colonial legislation. If we allow your position, what could be some of the effects for those groups of people in Canada that cannot assert certain rights?
I would like to direct the court's attention to the 1996 Supreme Court of Canada case of the Crown and Gladstone. And in the case of Gladstone, it emphasizes the fact that under Section 35, the rights are dependent on the differing circumstances of the community. And so within Canada, how an Aboriginal community's circumstances, even through applying the same test, for example, for Aboriginal rights, could result in a different result due to their circumstances. To return,
is it your position, Counsel, that the Lakes Band and the argument that's being made by Mr. Desautel, it would not necessarily apply for every Indigenous group that had been separated from Canada and currently resides in the United States? And what test would you consider whether or not the person would be granted, rights under Section 35 versus the Indigenous groups that wouldn't be able to access Section 35 rights?
we submit that Section 35 should be opened up and extend the scope of Section 35 to Aboriginal peoples located outside of Canada. However, in the case at bar and in, for example, future cases, what this case could provide is that for those groups who do have that historic and ancestral link to Canada, to be able to come forward and be included under Section 35. And that is something that is unique to the Lakes tribe in the case at bar. And so while that Aboriginal rights must be addressed on a case-by-case basis, and so in the future, if an Aboriginal group outside of Canada had no historical or ancestral tie to Canada, that question might be answered differently in a future case by the court. However, in the case of the Lakes tribes, they are without a doubt the modern successors of the Sinex, and that's not in contention by the dissent, and our friends also did not take issue with that. To exclude the Lakes tribes from the phrase Aboriginal peoples of Canada under Section 35 would be to ignore the historic ties that this group has to Canada. As noted in paragraphs 17 and 23 of the trial decision, the Sinex are referred to in the historical literature interchangeably as the Sinex or the Lakes or the Air Lakes people, and that each of the names by which the Sinex either referred to themselves or were identified by others serves as evidence of a clear and ancient link between the Sinex and the Arrow Lakes region. Furthermore, we're not looking to extend the Constitution extraterritorially, as our friends may have submitted. And that is because the right that Mr. Desautel is claiming today is within British Columbia, it's within Canada's sovereignty.
Okay, I'm going to interrupt you there, because if we're going down this road of granting rights to Indigenous groups outside of Canada, you're indicating, yes, we're giving them rights to hunt within Canada, but this also, it could very well apply to groups that want to exercise more rights, such as land title rights, such as rights to be able to extract their own resources from these lands. So what are we talking about here in terms of people who are extraterritorial from Canada and would be able to have rights that would very well affect the Constitution and the fact that they are not living within Canada?
So Section 35 as part of the Constitution does have constraints. We're not submitting that Section 35 is limitless. There are limits on Section 35. And as recognized in Gladstone, there are times when limits are a necessary part of reconciliation as part of that broader picture. But we would submit that in the case at bar, that is not necessary. And
okay, but what I'm saying to you is that if we start going down this road, what you're suggesting is that there be a two-tiered level of rights that Indigenous groups would be able to access. If they live in Canada, they would be permitted to do things like claim for land title, to be able to extract resources, to be able to use the land. But you're saying that this would be considered differently for non-Indigenous or non-Indigenous groups who are not living within Canada? That it would be considered differently based on geographic location?
It would be considered the same for all Aboriginal peoples who are included under the scope of Section 35. And the way the court would avoid those deleterious consequences, if I'm understanding the question correctly, is that there are already sufficient limits in place within our existing Aboriginal law and structure. There are tests for Aboriginal rights that the claimant must also meet in addition to passing the threshold test under Section 35. And so if we were to widen the scope of Section 35, then groups could bring forth their claims, but they would still have to pass the existing tests for Aboriginal rights or land titles or title claims. And if they don't pass that test, then they would not be able to exercise that claim. And so we would submit that the court's existing Aboriginal structure and law, as it has already been laid out in the jurisprudence, has sufficient limits within it.
Okay, so what you're saying is that Section 35, once these rights are determined to be held by groups not within Canada, that they would be able to exercise full Section 35 rights if they were in the same position as groups who were in Canada. There would be no difference in terms of how the test would apply.
No, the test would apply the same. And as the test differs, the test is the same, but the result could differ based on the circumstances of the Aboriginal community, as the rights exercised by Aboriginal communities are dependent on the circumstances and whether or not they can meet, for example, in the test for Aboriginal rights, the requirement for continuity. Our friends also cited the philosophic context of Section 35, and in particular that in order to claim a Section 35 right, Aboriginal peoples must be full participants of Canadian society. And that was iterated in the 2010 Supreme Court of Canada case of Beckman and Little Salmon Carmacks First Nation. However, what Beckman emphasizes is that they must be full participants of Canadian society, but in a mutually respectful long-term relationship. And the issue in Beckman was about treaty rights, not the interpretation of Aboriginal rights. But what treaty rights and Aboriginal rights do have in common is that they engage that fiduciary relationship of the Crown, and the honor of the Crown is—
Okay, Counsel, my question is, if you have a group who is outside of Canada and who has Section 35 rights, as you're requesting by the court, how would they be full participants in Canadian society?
Justice, reconciliation under the purpose of Section 35 is an ongoing negotiation process. And so at this particular moment in time, I see that my time has almost elapsed. If I may briefly answer the question and then conclude.
Yes.
Because reconciliation is an ongoing negotiation process, what we're asking for the court to do today is to take a step forward in that process. And it may be in the future, in a future case, where those direct issues are at hand and full submissions are made, then the court would be able to address that fully and continue that negotiation process.
Time.
Any further questions? That concludes the first submission on behalf of the respondent. Thank you.
Yep.
Good afternoon, honorable justices of the court. My name is Avery McKinley, and I will be concluding the final submission on behalf of the respondent, Mr. Richard Lee Desautel. Our final submission is that the requirement of continuity was met in the lower court's application of the Vanderpeet test. In regards to the application of this test, the role of this court is to rely on the findings of fact made by the trial judge, as it is a fact-specific exercise, and to assess whether those findings of fact were both reasonable and support the claim that an activity is an aspect of a practice, custom, or tradition integral to the distinctive culture of the Aboriginal community or group in question.
So, counsel, is it your position that we need to defer to the trial judge for factual findings?
Yes, Justice, the factual findings are not at issue in this case, but rather the conclusion drawn from the evidence is what our friends take issue with, and what we submit is not at issue.
Well, Justice Cote found that there was a legal error when it came to the factual findings. If the factual findings are not at issue, then we could probably go home right now. So do you think there was a legal error, or are you submitting that there was not?
There was not a legal error, Justice, and this is for two reasons. There are two reasons brought up by the dissent as to why there was a legal error. The first is that the hunting practice in Washington, as opposed to in British Columbia, they state that it's a site-specific requirement. And the second is that, to the dissent, the evidence that the connection to the land existed in the minds of the Lakes tribe is seen as insufficient. In regards to the site-specific requirement, we submit that this does not provide an adequate basis for precluding an Aboriginal right. The case of Vanderpeet emphasizes that the courts must not focus entirely on the relationship of Aboriginal peoples to their land to the point that they may lose sight of other factors relevant to the identification and definition of Aboriginal rights.
Okay, so Counsel, what you're saying is this idea of continuity. You're saying that the dormancy period of this tribe and exercising their right was not long enough in order to be able to take away that right. However, you know, Section 35 was affirmed as part of the Constitution in early 1980s, 1982, and yet we're not hearing about this argument until, you know, 30 years later. Can you please indicate to me what your position would be in terms of how dormant can a right be before it's exercised again? How patient does the Canadian public have to be in order to, you know, recognize these rights or not?
Yes, Justice. The issue regarding the Vanderpeet test in this case is not the temporal gap in continuity. This is stated at paragraph 130 in the case at bar and also expressed in the case of Vanderpeet, which states that an unbroken chain of continuity is not required. Justice Kasper, you also mentioned that there are factors as to why there was this dormancy period, and I'd like to briefly just expand on those factors, which include the European arrival and influence, which ultimately led to the 1846 Boundary Treaty, acts making the hunting practice illegal, such as the Game Protection Amendment Act of 1896 and the Wildlife Act in 1996, and the impacts of residential schools. In Vanderpeet.
Okay, but do we have any type of factual evidence that, I mean, the Lakes tribe was not in Canada during the period of residential schools. So how do we consider that in terms of being a factor as to the dormancy period?
Justice, because there were residential schools in Canada and in Washington, the effects of residential schools ultimately put Aboriginal people in the position of not being able to truly exercise their practice, as they likely feel very unsafe doing so. I'd also like to draw upon the case of the 1996 decision of the Crown and Adams, where the site-specific requirement was first set out. In that case, the court intended to widen and not narrow the scope of Section 35 rights. In Adams, the court held that Aboriginal rights are not inherently based in Aboriginal title to the land, which is also why there are two separate tests, as discussed previously, one for Aboriginal title and one for an Aboriginal right. So in concerns about the right being site-specific, if we follow the reasoning in Vanderpeet in considering the Aboriginal perspective, and also consider that this court should not be narrowing the scope of the Vanderpeet test, as this would run contrary to what was intended in Adams, the hunting practice in Washington can be used to show continuity, and to avoid unnecessarily narrowing the scope of a Section 35 right, this court can turn to the Aboriginal perspective and the underlying purposes of Section 35. The Aboriginal perspective in this case includes the evidence that the connection to the land was still present in the minds of the members of the Lakes tribe, as found at trial and reiterated at paragraph 8 in the case at bar.
Do you have any evidence to submit to the court, or do you have anything that you would like to point out to our attention to distinguish the significance of the Canadian territory to Mr. Desautel versus the territory in Washington, D.C.? Is there some type of difference in what he was doing in Canada that he could not do in the United States, and why we should consider that?
Yes, Justice. It's actually stated in paragraph 124 of the British Columbia Provincial Court decision of this case, where Mr. Desautel, he talks about being a member of the Lakes tribe and a successor of the Sinaiaks. He states, when I come up here, I am walking with my ancestors, and it just runs chills up and down me that I can be where my ancestors were at one time and do the things that they did.
Now, Counsel, I'm going to throw you on a tangent here, if you don't mind. Okay. So we're looking at the Constitution Act, which was written in 1982. It uses the phrase "the Aboriginal peoples of Canada." Why are we not looking at from a 1982 perspective? And I get what you're saying. This court is absolutely sympathetic to these concerns. Is that not a political question and not a question for this court?
Justice, when we look within the Canadian legal order, we see that the doctrine of Aboriginal rights is recognized and affirmed by Section 35(1). And what separates Aboriginal peoples from all other minority groups is the fact that when the Europeans arrived in North America, Aboriginal people were already here, living in communities on the land and participating in distinctive cultures as they had done for centuries.
Is it not for Parliament to say that? Is it for this court to make that pronouncement?
It is absolutely for this court to make that pronouncement, because this is an interpretation of Section 35, which is owed deference to this court. And this fact that they are a distinctive minority group is what mandates their special legal and now constitutional status, as stated at paragraph 30 in Vanderpeet. To disregard the Aboriginal perspective in this test would be undermining the very purpose of Section 35 and the Vanderpeet test, which it underscores, which were enacted as a constitutional promise to protect Aboriginal rights. Based on the evidence.
Is there any concern, Counsel, that extending Section 35 to Indigenous groups outside of Canada may harm or limit or narrow in some aspects the rights of Indigenous groups already within Canada?
No, Justice, because as stated in paragraph 69 of Vanderpeet, this is determined on a case-by-case basis, and it does recognize that Aboriginal rights are not general and universal, but also there are limits in place already in regards to the application of tests, and this would not be undermining Canadian Aboriginals, as we've already discussed that the Lakes tribe are successors of the Sinixt, which does make them of Canada.
So in your position or submission, what should we do? What should the government do to ensure that rights are balanced? What process would you support in terms of ensuring that rights are not lost as a result of allowing Indigenous groups outside of Canada to exercise 35 rights?
Yes, Justice, because groups of Canada outside of Canada are not implicated in the process to the same degree, the scope of the Crown's duty to consult with them may differ in the manner in which it's given effect, as stated in paragraph 76 of the case at bar, and that the existence of a right will be specific to each Aboriginal community. There are also just things that the courts are able to do now that we weren't able to do perhaps 30 years ago in regards to the new ongoing technological developments, such as the fact that we are in an online courtroom today. We are able to have more constitutional conferences and ways of consultation process as well. A consultation process involves a balancing act of giving and taking and negotiation, as you restated to our friends. To conclude, Justices, in the words of Richard Lee Desautel, when I come up here, I'm walking with my ancestors, and it just runs chills up and down me that I can be where my ancestors were at one time and do the things that they did. Mr. Desautel is merely defending his right to hunt where his ancestors did. And today our friends have responded to Mr. Desautel's claims with submissions that would narrow and defeat not only the promise of Section 35, but would be using this court, with all due respect, as an instrument of the law to cut off ancestral connection that, despite all odds, survived colonization. Based on the submissions made by my colleague and I, this court has the opportunity to uphold Section 35's promise to its Aboriginal peoples, particularly in this day and age. We respectfully request the Supreme Court of Lions Cup to not only dismiss the appeal and uphold the lower court's decision, but to step towards reconciliation, decolonization, and healing. Barring any further questions, this concludes the submissions on behalf of the respondent.
Thank you, Counsel.
Thank you,
Thank you.
justices.
Thank you, Counsel. The panel will reserve, and we will send our decision with proper notification. So Counsel can exit at this point. Thank you.
Thank you.
Nice try, guys. Good job, everyone.
I'm gonna say likely not.
I think one of our moderators might be recording this in error.